Good afternoon. We're here on the Family Law Docket B. I'm Commissioner Dave Nelson.
This matter is before the court on mother's motion to modify the parenting plan as well as a contempt. There's some new information that's came to light as of Thursday of last week. The child in this case attempted, and I believe that it's pertinent to have that information before the court before making a ruling. So I'm asking for the court to set this matter over at least a week, if not two, to present that information.
And Your Honor, thank you. I am objecting to that. Everything has been filed timely, and there really are no filings due. So we are asking to proceed today.
How is that information going to affect this motion, do you think, Ms. Gilmore?
The child's mental health is pivotal to the motion for modification. It's asking for Mr. Fuller, the child's abuser or alleged abuser, to come back and live in the home at least a majority of the time. So if the child has just attempted to commit suicide less than 7 days ago, I think it's extremely pertinent to this court's decision on making any sort of modification to the parenting plan.
And Your Honor, I'll just indicate, if I did refer to the GAL report, that the child has attempted to commit suicide in the past for having her cell phone taken away, and it had nothing to do with Mr. Fuller. So I don't think that this has anything to do with the issues before the court.
I disagree with that dissertation of the facts of the case, but I do think it's extremely important to have this information before the court.
All right. I don't know whether it has anything to do with Mr. Fuller, but I think Ms. Gilmore should be given an opportunity to develop that information. It would be relevant to the decision. So I'll put this over 1 week. Sorry, I don't have that top of my head. That would be the 7th.
So Your Honor, just to clarify at this point, all filings per the court rules are already in. There are no other filings that are allowed. And that wouldn't, setting over 1 week, there's not going to be any additional filings.
The court can consider good cause for supplemental declarations, and that's what I'm asking for the court to do. And that, based on that set over, the court's allowing that.
All right. I am going to put it over 1 week, both of the Kindle issues, the order to show cause and the order for a motion for modification. And you'll have to argue the good cause next week with Judge Fassett. Okay.
Thank you.
Let's just sit tight on that. Okay.
Thank you, Your Honor.
Any other requests for set over?
Your Honor, I was asking if I could get another set over just to get all my documentations and filings. I have all my paperwork.
Before you go on, let me just find that case and call it here. And I'm sorry, I'm not seeing it. I remember your name when I read it. What is the name of the case?
Mansker.
Oh, okay.
And I got a letter from Ellie Cotto. I tried filing yesterday, but I have the wrong cover sheet for the placement of my 2 younger children. So I just have a lot of paperwork that I just need help with from legal aid for the cover sheets of all the stuff I have been doing and complying with.
All right. We're here on a request to appoint a guardian ad litem today. Do you feel you need more time to prepare for that request?
Oh, no, not at all.
Are you in agreement with that request?
The guardian ad litem, that's fine.
Yes, with the request for a guardian ad litem to be appointed.
Okay, yeah.
Right. Are you here on that case, Ms. Winkles?
I am, Your Honor.
All right. Was that your motion for the guardian ad litem?
It was, Your Honor.
All right. And I know Ms. Bowen was represented until recently, but it sounds like she's in agreement with your request for a guardian ad litem. Okay. So that leaves Ann Height and Tina Day. Ms. Bowen, do you know any of those individuals?
I do not.
Okay. I'm going to appoint Ann Height as the guardian ad litem.
Okay.
So I'll do an order to that effect.
And I was just curious about the supervision. There paid supervision to be supervised. Is that a whole nother case or another time?
My notes say supervised visits 2 hours a week. Were those professionally supervised?
Okay. Is there any way that I could get that someone has a background check and fingerprints to be able to supervise from the CPS?
And I'd object to that, Your Honor. It's professionally supervised, so there's a statute. She can come on a motion to change it.
All right, Ms. Bowen, I think part of the reason supervised visits are ordered is because the supervisors keep detailed notes of the interaction with the children. And that's really helpful to the court and also to other counsel. So for right now, I think we're going to leave them professionally supervised. If that goes on a month or two, if you want to bring a motion to change that, you can do that.
Okay.
Okay. All right. Thank you then on the Ma'am Zandy and Ms. Holloway, you're here.
Yes.
Okay, and you're representing yourself. Okay. So we're going to hear from Mr. Zandy first, and then Ms. Holloway, you can respond, and then Mr. Zandy will get the last word. He's got the burden of proof on this motion. Okay. All right, Mr. Zandy.
Thank you, Your Honors. The court said, well, I do represent the respondent moving party to the motion for contempt before you today, namely Michael Paul. And this motion is pretty clear on its face. So I'll keep my comments brief and to the point. I think there's certain provisions in parenting plans that we sometimes take for granted, but they're in there for a reason and they serve the utmost importance. And this is one of them. This is one that unfortunately has been an issue from the beginning of this case as it pertains to Camden and his mother. And that's essentially involving the child in various aspects of this litigation, most specifically as it relates to the parenting plan and the schedule. This is a child, and this is one that is sensitive to a lot of the issues around him. Now, this is one where we've been in prior proceedings and addressed the issue of Camden getting fed information that is, quite frankly, he shouldn't be. This is one where the mother has continued to impress upon this 16-year-old that it's essentially his choice to do what he wants, and is now resorting to pressuring him into decisions that are only beneficial for her. We have had a GAL investigation in this matter. We've had orders to this effect, and the order is pretty clear, stating under paragraph 14 of the parenting plan that neither party shall share with the child information regarding the legal status of this case, any financial negotiations underway, or any possible scenarios. It impresses upon me that child comes back from visit with mom, upset, states that mom was once again informing him of this process, telling him that there was mediation scheduled and that apparently Washington is a mother state and it's going to end up in a 50-50 parenting plan, and he essentially better just acquiesce to that. Puts pressure on him related to trial and the such, informs him of mediation dates and informs him of what's been filed and what's happening in this case. And this is a 16-year-old kid who would just rather do anything than be hassled with those types of communications. In response to that, my client knew something was going on. We didn't know that apparently Camden had reached out to the GAL, informed her of this, and then in response, this is the first time that I think I'd ever really seen one parent not only agree that, yes, I included my child in these negotiations and these conversations, but actually records the child and gives you a transcript, essentially, that conversation while Camden's trying to watch a football game. So if you look at that and the communication on that, I think it's clearly willful, it's clearly intentional, and it clearly violates the existing court order that was signed back in November of this year. So it's or last year, excuse me. So it's relatively recent. Everybody knows better. This is a case that's been somewhat contentious. Obviously, we don't like to bring these types of motions a couple of months prior to mediation. But again, we've got a child who is reaching out to the GAL, has made it abundantly clear that he does not want to be in the middle of mom and dad. But mom is quite literally putting him in a tug of war that is unnecessary and violates that very specific, very clear court order. It's contempt. Again, we are asking that you find as such. We are asking that you make a finding that it was willful and intentional. Are asking for a contribution in attorney's fees and costs, $750 in attorney's fees, $100 for a civil sanction, as that's required by the statute. And I'm not sure how we impress this upon Ms. Holloway any more clearly than to say that she just quite simply needs to not involve the child in anything related to this litigation. This child's voice has been heard, and that was heard through the GAL. That was it, and that's all it should be. But unfortunately, he goes to mom's and keeps getting churned back into this situation of mom giving him information that is completely unnecessary. I don't think there's any other way to describe her communications, and that transcript that she provides, along with pictures of the child, is completely unnecessary and completely and potentially harmful to this young man going forward. We are asking for the contempt. We are asking for the remedies as cited in my client's motion.
Right, thank you. Ms. Holloway, I'm going to change my mind here. I want to hear from Ms. Height, and then you may want to address both Mr. Zandy and Ms. Height. Okay. Ms. Height, anything you would like to add?
Very briefly, Your Honor. My communication with Camden during this particular amount of time has been pretty brief, and I think you have a copy of the text communication in which he expressed his uneasiness about what was going on, and that it had happened he was getting in touch with me just after he had left to visit with his mother, and he was upset about that. I would like the court to know this is just a fine young man. He has been forthcoming with me previously. His wants have been clearly stated to Your Honor through the documents that you've received, and I am concerned that he has distress over this that is unnecessary.
Were you surprised to get the text from him on that issue, or was that consistent with the communication you've had with him?
I wasn't surprised to receive communication from him, but I was surprised that it was still an ongoing thing because it had been addressed previously. And I felt that in the report that I filed, it was very clear that that was a concern for me during the course of my investigation. And that I had made it very clear, I thought, to both parties that this kind of communication was off limits and that documents should not be left out where he could access them. He should not be a part of those kinds of conversations. So I wasn't surprised that he got in contact with me because I feel like we have a comfortable enough established relationship that he could feel comfortable doing that. I was surprised that it was still happening.
Well, I think the language in the text from him reflects that he did feel comfortable contacting you. All right, Ms. Holloway.
I apologize. It's nothing willful or intentional. I was not trying to cause distress. This case has been. I'm trying to figure out how to prove Camden's involvement with his dad. He and his dad. I've been saving this for trial, but I need to just get it out now. His dad promised him that if he went along with all of this, he would get child support checks deposited into his bank account. That the child support would go directly to Camden.
Object anything that's not part of the pleadings and also based on hearsay. I think that's appropriate.
That is the rule, so I'm going to have to object to that or sustain that objection.
Camden reported to Ms. Height that everything was going wonderfully with our family, with our home. Everything has been great here with Camden. We've had no issues whatsoever. I sat down on the couch with my family and I thought, hey, we're having such a good time. Maybe he's more open to being here a couple more days. So I simply asked him if he was open to Wednesday through Sunday. It was not trying to involve him in the court process. It was just communicating with my 16-and-a-half-year-old son. He's not 6. I'm not involving him in the middle of this. I hope. I apologize.
Ms. Holloway, the concern that I have is you mentioned to him, it sounds like there was a mediation coming up and other issues dealing with the timing of the trial, which Mr. Zandy's concern is that looks like, whether you intended it or not, put undue pressure on your son. I
understand that. I think that's just part of my thorough nature. Our son keeps saying he wants this over with. Everyone wants it over with. So I'm letting him know, we have this coming up, and if this doesn't work out, then we have to go to trial, which, again, he's learning about government. He's learning about all this stuff in school, so he knows that. But my hope was to have something that I can bring to mediation. Something from my son. So we're not, finishing this when he's 18 and when it doesn't matter. I apologize. I'm so sorry. It's not. And I need to note that he's not stressed. He even said in his text message to Ms. Height that he's not stressed about it. And Mr. Zandy said that he informed Michael later that he texted Ms. Height, the drive from my home to their home is 30 minutes. And he texted Ms. Height 9 minutes into that drive. There's no way that that was an independent text message. They're involved. They're telling Camden what to do, what to say. And they're mirroring everything one another says. And I feel like there's nothing I can do or say to get anybody to listen. Michael's declarations are filled with lies, and I have proven all of them wrong. I have proven all of them to be lies, and nobody listens. And I know Mr. Zandy has an obligation to the court to be honest, to come forth when he knows his client has lied. And that's not happening. And I don't know if it's because he's not.
I understand. She's arguing Mr. Zandy. It's fine. All right. Anything further?
I just want to note that it should be concerning that I recorded the conversation. Michael's absolutely right. It should be concerning. I have come to a place where there have been so many lies told. So much.
We're not addressing lies here. We're addressing whether you inappropriately discussed the case with your son.
I don't feel that it was inappropriate. I feel that it needed to happen.
Okay.
He's 16. He's almost 17.
All right. Mr. Zandy, any response?
Just very briefly, whether she thinks it was appropriate or not, the court has made a specific ruling that that's not to occur. The GAL has given input that that is not to occur. And the findings throughout this case have been that Camden is highly impacted by those types of communications, which is why the court instituted that order last fall. And then lastly, I think it's interesting if you look at that transcript that she provides, Camden's response to this. Camden's watching a football game on the television. Mom's having this conversation with him, which is largely one-sided, asking him questions, and every response he gives typically is geared towards what he's seeing on TV with this football game, which clearly shows us the child who does not want to interact or answer these types of questions or get involved in these very types of discussions or scenarios. And of course he doesn't. He's a 16-year-old kid. He should be allowed to be a kid. He should be allowed to enjoy things that 16-year-olds do. And getting involved in mom and dad's dramatics through court is certainly not one of those things. So I think, again, it's clearly willful and intentional. And as far as the being candid with the court, really, there's really no reason to fabricate or expand on the truth of either me or my client, because the transcript unfortunately says it all, and she provided that, and it's in violation of the court order.
All right, thank you. The order, that's a fairly typical order, is that the parents will not discuss the case with their children, particularly older children, 14, 15, 16-year-old children, is because it puts them in the middle. Children love their parents. They love both parents, and they want to please both parents. And if one parent starts discussing the case, then it just creates an uncomfortable environment. Now, Ms. Holloway has indicated that she said, we're going to mediation, and if we can't resolve it, we're going to go to trial. Well, there's an implicit message there that either if you don't agree to this, or if you don't help me out, if there's something that you can't do for me, then we're going to end up going to trial in this case. And that's a lot of pressure to put on, particularly an older child. Was it intentional? I think she said several times that she felt she had to do this, she had to do it to oppose things that were going on with her with the father. And from Ms. Height and from the order, it's clear that Ms. Holloway was informed that she shouldn't do that. So I am going to find contempt. I'm going to award $500 in attorney fees, and then I'm required to assess a $100 sanction. And I want to strongly say from me as the judicial officer, nothing about the case should be discussed with your children, okay? If it happens again, then the sanction will go up and I will award the full attorney fees that are being requested by Mr. Zandy. And if it happens after that, the sanction will continue to go up. Again, this is a really important order, and it's in most cases, and it's to protect the children in a marriage. And I want that order adhered to in this case. Okay. All right. Thank you, Mr. Zandy. Did you provide an order? I don't
thoughts
see
on it, perhaps not. You want to set the, what are we doing with your presentations, Your Honor? We
should probably put it on my docket at this point, because I don't know if I'll be back on this one. That would be on March 8th at 9 o'clock.
Okay. And Ms. Holloway, I'll send you that out here within a day or two via email, like we normally do.
And Ms. Holloway, please note that time. I do these motions on a different date. So it's going to be on Wednesday, March 8th at 9 o'clock. If you want to have any comment about the order that Mr. Zandy puts together. That's a presentation, right? All right. Thank
Correct,
you.
Your Honor.
So Ms. Hegdahl, on Hegdahl versus Cook, this is a presentation, but you filed an opposition, and I was not the one that made the initial ruling. And so Judge Fassett has to hear that. So we need to put this case over a week so that Judge Fassett can be back and make the decision on the opposition. Okay?
Okay, so what is my new date then?
That will be March 7th. Mr. Lawrence is here. Ms. Dow is here. Mr. Zandy's here. Maybe we should hear from Mr. Lawrence first and then go from there.
Your Honor, I've had a chance to meet with both parties. I had a home visit with Brandy and the children on February the 15th. The next day on the 16th, I had a home visit with Stephen. And my discussion with Stephen centered heavily around his drinking. And he agreed to voluntarily undergo a substance abuse evaluation, and he's exploring getting into a parenting class. And at this point, he hasn't, to my knowledge, gotten that scheduled yet, but that was his intention.
Mr. Zandy, what else needs to be done in this case other than get an update from Mr. Lawrence?
I don't think anything, Your Honor. I think we're kind of trailing that criminal matter, which I understand there's either a pretrial or readiness or something for the end of March. My understanding is that's likely to get continued a ways out. I don't think there's any urgency in this case, given the scheduling dates of that criminal matter. So I think we can kind of sit tight now, let the GAL evaluation run its course. We've resolved the issue as to the home. So I think we're in a position now of, sit back and hope that evaluations get done and hope that we have a ready or timely resolution to that criminal matter.
Ms. Dow?
Your Honor, I believe my client has completed a mental health evaluation with a parental risk assessment. I believe that was done on the 23rd of this month. I cannot confirm that he's got a confirmed appointment for a drug and alcohol evaluation, but he did tell me, as well as Mr. Lawrence, that he was scheduling that. He's got to work around his work schedule. But so far, he is being very cooperative about obtaining the necessary appointments, doing what he needs to do here.
Okay. Do we need to set a review hearing at this point?
I don't think so. I think we can kind of let it ride, and then if we need to or something comes up, I think anybody can note it back up. It's probably the cleanest way to go.
All right. It looks like the final report is due on May 10th. So I just wanted to let the parties know about that date. Okay. All right. Sounds like we're moving in the right direction. So.
Thank you.
Yeah. All right. We're here for the final GAL report. And I'm not sure I saw it. Has that been filed, Ms. Turnbull, or did I miss it?
It should be filed. Yes.
Okay. Let me see. What's this one?
I did mail. Oh, I did actually mail it in.
I did get it. Okay. All right. It was in the court file as of yesterday. Did everybody get a chance to see the final GAL report?
Yes, Your Honor.
Yes.
Are we in a position to make decisions regarding that report or based on that report, or do we need some time to digest it and look at it?
I'm prepared to move forward. My request is going to be to adopt the recommendations. I did see that Ms. Jacob filed a declaration it was late last week, the 24th, so I don't even know if Your Honors had the opportunity to review it. I won't speak on her behalf, but largely what I reviewed when looking at her declaration is she was in agreement with the GAL recommendation, with the exception of just doing a week on, week off, as opposed to the 3 days on and off and the alternating weekends that the guardian ad litem had recommended. My client's comfortable with either of those. I think given the age of Bradley, that he is so young, I think being away from a parent for a week at a time at this young of an age, I think the guardian ad litem's recommendation of the 3 on, 3 off and the alternating weekends is probably more appropriate at this time. But I would defer to the court. That is the major issue. Secondarily is the name change. The guardian ad litem is proposing that the child's name be changed to include my client, who is the biological father of this child, to have his name included. Currently, the child only references the last name of Jacob, which is mother's former married name. I understand that she still has it and is hyphenating at this point, I believe. But the guardian ad litem had made the recommendation of changing the child's name to include my client's name. My client had made the request that the child's last name be changed to Jones. That is still his request today, although I understand that the guardian ad litem had recommended a hyphenated name of either Peppers Jones or just Jones.
Ms. Jacob, you can respond.
The only reason I wanted to do week on, week off is I have 2 kids already. My oldest son does week on, week off, and it started right around this age as well. And I feel like having both of them at the same time, I won't have any questions for my older kid as to where's Radley, why isn't brother here? And I've talked to Skylar about doing week on, week off, and he said that he would be okay with that as well. My only request is that he uses my daycare provider. I pay for it, so I feel as if he should be using it versus staying at home with a relative or somebody else. And then I also put in my declaration that I want to change his last name too. And I'm pretty sure Skylar was in agreement with that too.
Okay, let me hear from Ms. Turnbull, and then I want to go back to Ms. Bliss.
I think that's reasonable to continue with the same daycare provider and have consistency and continuity there. I do have some concerns about the 1 week on, 1 week off at this point in time. Even if we could do a transition, given that that Bradley has not been in, spending as much time with Dad in the last number of months, I think having a period of time where he has a transition to get more comfortable again would be helpful before he spends. So 1 week on, 1 week off would be helpful to make sure the little guy's comfortable. If we could do even 6 months.
So you're not sure that a week on with Dad is beneficial at this point?
I think a transition would be better.
Okay.
Before we jump into the week on, week off.
What is Dad's work schedule? Do we know?
Dad has changed jobs since I first started this, and so I don't know what his current employment is. I don't know if Ms. Bliss is aware.
And I don't have his current schedule in front of me. I'm sure I have it in the file downstairs, but at least for purposes of today's hearing, I don't have that in front of me.
If you want Mr. Jones to hop on, he is logged in.
Is Mr. Jones here? I don't.
Oh, yes, Your Honor.
Okay. So, well, let me ask Ms. Turnbull, if we do a transition, what would that look like?
Well, that's why I had suggested the 3 days on, 3 days off, alternating Saturdays, just to give Radley a period of time where he doesn't have so long away from mom.
Mr. Jones, what's your work schedule?
I work Monday through Friday, 7 a.m. to 3:30 p.m.
And if you had the child during your work, where would he go?
Well, originally, I agree with the daycare plan. So what would happen was that either I take him to daycare before I go to work, or I would have my mother, his grandma, take him to daycare. Okay. And I would pick him up afterwards.
Ms. Bliss, any response?
I don't have anything, Your Honor. I would just, remind the court that Radley is only 1.5 years old. So obviously a extended period of time away from one parent may not be in its best interest. I'm inclined to agree just based on experience that typically a graduated schedule is typically easier for a child to adjust. So I don't have any objection to Ms. Turnbull's 3-month or so transition, doing the 3 days on, off, and then alternating weekends, and then going into that week on, week off schedule. I do agree, at least with Ms. Jacob, that having that sibling relationship is appropriate as well.
All right, Mr. Jones, you're okay with the last name? That would be, are you agreeable to that? You're muted right now.
I agree, but at the same time, I don't know. It's just more of it was just an option for the GAL and Jacinda. But I'm willing to consider it.
Well, I'm going to make a decision about it in like 90 seconds. So,
yes, sir. Yes, sir. Yeah, you go for it, boss.
So, Your Honor, my client's perspective historically has been he'd prefer the child to have his last name. But if Your Honor does want to hyphenate it as recommended by the guardian ad litem, then yes.
Why not Jacob Jones?
Jacob is Miss Jacob's former husband's last name.
Right, I appreciate everybody's input. So I'm going to adopt the guardian ad litem recommendations as to visitation, which is the 3 days on, 3 days off, alternating Saturdays for 3 months. And if that goes well, then the court will consider going 7 days on, 7 days off, if that's better. Mr. Jones has indicated that he will use the same daycare. And I think when he's working, that makes sense. Ms. Jacob indicated she pays for it. It's a consistency for the young child. So I think that's where the child should be when the father is working. Other recommendations are that both parents attend parenting classes called Battles, Hassles, Tantrums, and Tears. So I am going to order that. The investigator recommends no disparaging remarks be made about the other parent. It actually sounds like you're communicating pretty well, but I am going to adopt that recommendation. And the investigator recommends that all information from the report be kept private. Well, the child's pretty young right now, so, but I'll adopt that. As to the last name, here's my take on it. When the mother was pregnant, she indicated that it was somebody else's baby. And Mr. Jones was not allowed to, or didn't know to be involved. And at one point, he decided not to be involved in the child's life. And then later, the mother called and said, you are the father. And I think because of that, if Mr. Jones was involved at the beginning, this would be rather than Radley Jacob. Radley is 1 year old. He likely is not aware what his last name is at this point. And so my order is going to be that his last name.
Okay.
Ms. Bliss, do you want to put together an order on that?
Yes, Your Honor, I can prepare those orders. Do we want to go ahead and put that on your?
Yeah, let's put it on March. Can we do it in a week on March 8th?
Sure. Yeah.
We're not, just for the clerk, we're not changing the docket of this matter. It stays on Judge Fassett's docket, but for this presentation, we'll do it on March 8th at 9 o'clock. Are we ready to go forward in this case? I saw it was put over a few times and I didn't know what you wish to do today.
It's Grover Peters for the petitioner, Your Honor, and the reset was mostly my fault for some conflicts, but Mr. Zandi's been kind enough to cooperate and get this before you today, so I appreciate his assistance in that regard. And my client, Mr. Despain, is present as well.
Yes, I see that. Mr. Zandi, are you prepared to go forward?
Yes, Your Honor.
And it looks like, I think today we're looking at temporary orders, which would include a parenting plan and child support orders. Is that right?
That's correct, Your Honor.
Okay.
Your Honor, on the motion for the temporary family order, there is a modification that needs to occur, and Mr. Zandi and I probably need to negotiate it. Originally, the parties had discussed selling the family home and then, selling the home and splitting the proceeds. Since that time, the parties have discussed my client retaining the home and paying Mr. Zandi's client her share of the proceeds. However, there needs to be a formal appraisal established to determine the actual value of the home. Mr. Zandi and I have had at least a preliminary conversation about that project, but we've not reached a resolution at this point. So that was in paragraph 14 of our original motion for temporary orders concerning the sale of the home. That's the only change in our original motion that's before the court today. Otherwise, everything that we submitted that was file stamped on January 20th remains unchanged at this point. Ms. Despain has moved out of the home. My client informs me back in December, she does come back and forth to pick up some personal items from time to time. They have one child, a 5-year-old child, and my client's employment allows him to have 7 days custody with his child, and then he goes back to work. So the motion includes a 50-50 visitation and parenting plan for their one child.
Okay. All right, Mr. Zandi.
And thank you, Your Honor's courts, where I do represent the respondent in this matter and the wife of the petitioner, as well as the mother of their 5-year-old child, Jameson. I think this is a case where we're fortunate to have two good parents, two parents who love their child and have done fairly well with a couple of hiccups along the way, as can be expected, trying to foster communication with each other and peaceful exchanges for the most part. So that I think that's, from a jumping off point, that's positive. If you look at the competing proposed parenting plans, you'll see a couple of differences, and that's kind of what we need the court's help with today. Although I think we're close on a resolution to that, there are a couple of differences. I believe Mr. Peters is correct that the work schedule is somewhat different. Although being in Longview, we get a lot of these mill type schedules of shift workers and such. The NORPAC schedule is different. It does afford Mr. Despain a week-long period every month of having, I believe it's Friday to Friday off from work. That's a benefit for everybody. But again, if you look at a 5-year-old child, and I'll get into some special considerations of Jameson here in a moment. If you look at some of those considerations, we don't want the child going a week at a time outside of primary parents, primary caretakers' custody. That's kind of where the dispute lies. So although we're close to a joint plan, we're at about a 55-45 or 60-40 split. We're still a little ways off. So with that said, my client has asked that she be deemed the primary residential parent. Again, this request dovetails largely with the traditional roles of the parents. My client tells you that she's been kind of the one that spearheaded efforts with doctors and teachers and the like. Her work schedule is such that she's readily available for the child to pick him up from school as necessary. And this is a little guy who has some issues. This is a guy who has been diagnosed with ADHD as well as oppositional defiant disorder. He loves dad. He's bonded with dad. He loves mom. He's bonded with mom. Again, that's all very good and positive. But the day-to-day functioning of the caretaking responsibilities and tasks has largely fallen on that of my client. Her concern is if you take a 5-year-old who, with these types of developmental issues with the ADHD, as well as the oppositional defiant disorder, has a hard time with change, has a hard time transitioning, which is why we think that kind of breaking up dad's week-long visit or his week off from work makes sense given the circumstances. We're asking, and you see in our proposed parenting plan, that Jameson be with my client during that week off for a couple of days to break up that time. We suggested Tuesday to Thursday. Again, we think that's appropriate. This is a child who is on an IEP at school. This is a child who, although he's doing okay, as well as can be expected, still has some transitional issues, and those are kind of the effects of that. So we are asking you to adopt our proposed parenting plan, which again gives both parties ample time. My client wants to preserve the relationship that Jameson has with his father. She wants to also recognize the fact that we've got a child who might need a little bit extra maybe support through this period with mom. Currently, my client, again, works the schedule as a hairdresser where she's more readily available to get off of work and tend to these day-to-day functions in the same capacity she has for the first 5 years of this child's life. And we're just asking that the court be cognizant of that and essentially keep the status quo related to it. You look at the family home, and again, this is, I would agree again with Mr. Peters that this is a case in which there is some bit of a change of course in this. Initially, it was, I thought, agreed that the parties were going to list that and sell it and split the proceeds. As you see in the declarations, the initial motion, that was agreed. I did have discussion with Mr. Peters a couple of weeks ago. Mr. Despain apparently has had a change of heart in that and wants to retain the family home. I'm not really sure where that leaves us. Certainly, if the court is inclined to allow that, or at least make some decisions moving forward, we're not in a position today to really determine what the house is worth, who gets it, or what we're going to do with it. If it's not agreed that it is sold, then I guess we've got to do some discovery, get the appraisal that council speaks of, or at least some CMAs to lock down a value, put that on a balance sheet, and go from there. So we are asking that the house be sold, but nonetheless, I understand that that's been kind of a changing course over the past couple of weeks, and how the court chooses to deal with that. Certainly my client will comply. My client details for you that she largely needs some financial assistance on this. There is a disparity in the incomes between these parties. She continues to work as close to full-time as she can as a hairdresser, but again, she rents space from a place. She's giving you information as to what she's earned in the recent past, going back to June of last year. And you can see that once she's basically an independent contractor. She pays for her own supplies, she pays for her chair, she pays for rent. So when you take out those costs, it leaves her with nets ranging anywhere from $1,500 to about $2,500 on average per month. We've detailed that for you. It's contained on page 3 of my client's declaration. But for purposes of support, we've simply put an income on there to her of net of $2,500 per month, which is about, or excuse me, $2,100 per month, which is about the average of what it is that she's bringing in on a month-to-month basis. In contrast to that, you have Mr. Despain, who works again at NORPAC in Longview. He recently received a $3 per hour raise. Now we understand is earning $31 per hour. I believe he's also entitled to shift differentials and overtime and the such. He also got a significant bonus, I believe of $4,000+ recently. He's in a far superior financial position to that of my client. Regardless of whose parenting plan you adopt, whether that's ours or whether that's Mr. Despain's, we recognize that there is a deviation for the amount of overnights he has with Jameson is appropriate, but we're asking for some transitional support. Now, we've deemed that family support, which is a combination of the alimony side along with child support, in the amount of $1,000 per month. In review of Mr. Despain's financial declaration, you'll see that he has significant funds for discretionary spending. After he pays out what his obligations are, he has roughly about $1,800 per month to do what he wants with it. My client doesn't have that luxury. She's currently living with her mother, living in her mother's bedroom. Initially, again, she moved in thinking that they were going to sell the house and split the proceeds. If that's not the course of action now, she desperately needs some financial assistance so she can get out on her own. I don't know if this house is going to be refinanced. I don't know if it's going to be sold. I don't know what's going to happen in the future. Where she's at today, expecting her to live under the gratuities of her mother doesn't make a lot of sense when Mr. Despain has the financial advantage that he does. My client's responsible for $400 per month for the Forerunner loan. Mr. Despain has a Subaru loan of about $200 and some modest credit card debt, in addition to the mortgage, which is about $1,500 per month. So he's got money available to him. Also asking for a contribution, attorney's fees, and costs in the amount of $2,000. And we're asked that be paid within 60 days of entry of the temporary order. And then finally, which seems to be a recurring theme this time of the year, we got to address what we're going to do on the 2022 taxes. It's our suggestion that the parties run some different scenarios, see what the best benefit to the community is, and file as such. Split the cost if the court is entitled or is inclined to adopt our recommendation or suggestion for the financials. Split the cost of any preparation 50-50 and get that done so that we can put that issue to bed. Client's primary concern right now is number one with Jameson. It's getting a parenting plan that coincides with the child's best interest, given some of these special considerations he has. And it's also financial. And again, given the disparity in earnings and what we do have related to the financial aspects of this case through the sealed financials, again, it does show that one party has significantly more funds than the other. And we're just asking that on a temporary transitional basis that somewhat level out.
Mr. Peters, any response?
Your Honor, obviously, we dispute and object to Mr. Zandy's representation that my client has significantly more funds than Mrs. Despain. Mrs. Despain is the one who chose to leave this marriage. Mr. Despain did not want this marriage to dissolve. It was against his wishes that she chose to leave. But if you look at our client's financial declaration, the gross numbers month to month, there's about $1,800 total difference between Mrs. Despain's income and Mr. Despain's income. So it's not significant, but Mr. Despain is the one that's taken on all the obligation to pay the mortgage and all the other expenses related to the home that the son has known since birth. It is the family home that Jameson has lived in since day one. We dispute and object to any representation that Mrs. Despain is the primary parent and the better parent. We would seek joint parenting for the child, and the 50-50 visitation schedule, which has been in effect for quite some time now, has proven effective and has been found beneficial by many studies. And for children with autism and ADHD and other deficiencies have been addressed by Mr. Zandy, that it's important that both parents be equally involved in those matters. So we would ask this court to approve the parenting plan that we've submitted to you and deny the parenting plan that Mr. Zandy has presented. Finally, we just ask that the court order that each party be responsible for their own attorney's fees. With that, I'll let our pleadings stand on their own, Your Honor, and save us some time and let you make your ruling. I appreciate your time. Thank you, Your Honor.
Thank you. So they've been doing a week on, week off for a while?
Yes, Your Honor.
I don't know that it's been week on, week off. I think it's kind of revolved around Mr. Despain's schedule. So I don't think we can say week on, week off. I think it's basically when he's off, he has Jameson. They've been trying to accommodate that with obviously some tweaks here and there.
But Mr. Despain has had the child for 7 continuous days at a time. So there's no representation that it's important that he have anything less than 7 continuous days whenever he has visitation with the son.
I think that is correct. On his 7 days off of work.
The thought is whenever he has 7 days off at work, that would be his week with the child.
Yes, Your Honor.
And it may not be week on, week off. It may be 2 weeks gap in there.
Correct, Your Honor.
Okay.
He has a week off one time per month, 7 straight days. And that's usually a Friday to Friday. And our position is you break up that 7 days and give my client a little space in between.
And he gets no other, well, Mr. Peters, are you saying no other visitation other than that 7 days per month?
No, Your Honor. We're asking for normal visitation. But Mr. Despain's present. If you'd like more clarification about his schedule, I'd ask that we could bring him on and have him explain the schedule if it's okay with you, Your Honor.
Yes. Sometimes he has 3 days off. Sometimes it's, I believe, 1 day off. It rotates per month, but every month he has a 7-day off period.
Okay. And so when what you're saying, Mr. Zandy, is when the 7 days comes up, that's too long a time for this particular 5-year-old. I think it's 5.
Yes.
And so we want to have it go like Sunday to Tuesday and then Friday to Sunday.
Well, whatever you want to do with that, whenever the court thinks is appropriate, yes, because there has been some transitional issues coming back after 7 days with one parent for a 5-year-old, we think is just kind of an extended period, probably too much.
Okay.
And my client's still agreeable to him having the days that he has off. He has the child throughout the course of the month. It's just the dispute seems to be on that 7-day period he has. I think which is.
And again, Your Honor, I think
that's where the discussion lies.
Yeah.
Correct, Mr. Peters?
That is where the dispute lies, correct, Mr. Zandy, yes.
It sounds like the child has spent 7 days with the father already on those particular days off. It also sounds like the parents are fairly cooperative. At this point, I think the schedule where Mr. Despain gets the child on his days off, including the full 7 days off, is what I'm going to order, with no break in that time. I see the break during that 7 days is significant. He may want to go somewhere with the child. The break itself could be disrupting to the child, given some of his issues. So I think the full 7 days is what makes sense. As to the house, I think we need to give a little room for people to change their minds. At one time, Mr. Despain and Cassandra Despain agreed to sell it, and now Mr. Despain wants to refinance it and pay her share. I think he should be allowed to look into that. But I want you to know it's going to be on a fairly short rope. So I'm going to set a review hearing in a month, and the party should have either a CMA or an appraisal done by that time. And hopefully, I'm not going to hold anyone to it. It would be preferable if everyone agreed to what the price was that would need to be refinanced. Otherwise, in a month, I would like enough information before the court so the court can indicate what the value is going to be that has to be refinanced.
And we've done that and provided Mr. Peters with our CMA. I don't have any issue if we maybe get a second opinion or each party provide their own. There's a lot of good realtors in this town. Thankfully, if Mr. Peters and I want to maybe come up with a name to do a joint CMA, that might be the most cost-effective, quickest way to do that.
Okay. I'll set a review on March 28th at 1 p.m. I want that process completed to the point where if there's a dispute, Judge Fassett can decide what the value of the property is based on what you submit. And then if I were here, I would require the refinance to occur 90 days after that. And if it didn't, then it would be sold. Okay, so that's the timeline that we're working on. I think Mr. Zandy's client has a right to expect she's going to get some money in order to either buy a new house or help her with apartment expenses and things like that.
Yeah, we have no problems with the timeline, Your Honor. We'll get it taken care of.
Okay. So that I don't know if Judge Fassett will adopt that, but that's what I would do. All right.
You want me to include that in the order? Well, do you want us to include that in the order? Or do you want to just kind of?
In terms of the refinance time, I don't think that should be included. I just, okay. You know, it will be in the clerk notes, so Judge Fassett will see it. You've got Mr. Despain paying the calculation for child support is $716.80, and then you've got the actual child support amount as $76.80, and I think that's a typo.
$76.80, Your Honor.
It's what?
$76.80.
So you did mean $76.80 because of the residential
overnight.
Correct.
Okay. All right. I understand Mr. Despain is making a number of payments that are benefiting the community. I still think I guess a family payment, family support payment is appropriate. I'm going to set that at $750. And I'm going to do this. The longest that I see that going out is 6 months. And then it will go to child support after that. So it will, I see it as Mr. Zandy indicated, a transitional support. By that time, the house either is going to be sold or refinanced. So at the end of 6 months, then the argument will be what should child support be. On a tax return, I don't know if the parties have an accountant or if they use H&R Block, but there should be a fairly straightforward way to figure out which is the most beneficial. And if you're comfortable with the parties just splitting that return, if there's a refund or they each be responsible for half, I guess. Well, I don't know if I can say that. Let's assume there's a refund and they would split that in half. Okay. Have I left anything off on the issues that we talked about?
Attorney's fees, Your Honor, argued that each party should be responsible for their own.
Right. And Mr. Zandy's argued for $2,000. I think Mr. Zandy's made an appropriate argument that Mr. Despain not only makes more of it, has the capability of making a lot more through overtime, through bonuses and things like that. So I'm going to order $1,000 of attorney fees payable in 60 days.
And then two things. I think I know the answer to the first one. I just assume we not appoint a GAL and waste the time and money. Hopefully we can come to a resolution because we were so close. Mr. Peters, I'm assuming you agree with me, no GAL appointments necessary?
I agree, Mr. Zandy.
And you want a...
All right, we'll note that.
We changed some things. Do you want a presentation date with cleaned up orders, or how does Your Honor prefer we go about that?
How long do you think it'll take you? I'm going to assume Mr. Peters will put these orders together.
Correct, Your
How long
Honor.
do you think it'll take you to do that?
By the end of the week, Your Honor.
Okay. That may not be long enough.
We communicate pretty well, Mr. Peters and I think we could probably just get some agreed. We'll both sign off on it and have it presented ex parte, but just in case.
Let's put it on for presentation. Again, you've heard me, I do a regular docket on Wednesdays. So let's do it on March 15th, 9 o'clock. And it's called Pro Se Docket A. If you need to go over anything with me, we can handle it on that date. Okay. Right. Otherwise, if you want to, I guess you both sign off on it. Any of the judges can sign it, but if you want to route it to me, that's fine too.
I think we'll get an agreed order, Your Honor.
Okay. Good. All right. Any other questions?
Not for me.
Nothing further, Your Honor.
Okay. Good luck.
Thank you, Your Honor.